Hi everyone, this is Veronica. Today our topic of discussion is about recusal by judges or justice. We will discuss in detail about it. For my video updates and queries, you can connect with me on Instagram and Facebook because I feel together we can make a difference. Now see what is the relevance of this topic in your exams. It will be covered in your mains paper 2, executive and judiciary. At objective level, you should know about what is this recusal, and at subjective level, what is the significance of judiciary, impartial, independent of all external pressures. So in what context today we are studying this? Because what has happened recently, the Supreme Court judge, he recused himself from hearing a petition filed against the government's move to charge Omar Abdullah under the Public Safety Act. So Public Safety Act PSA is a special act in J&K. So he has been charged under it, but Supreme Court judge, he recused himself. So recusal means he denied himself from hearing a petition. So this case was finally heard by another bench. Now here we will talk about the rules of recusal, but before that let me tell you, if you have not subscribed StudyIQ till then, because a lot of students, they ask about specific videos, but they are already available on our channel, so that you don't miss any updates, you can just hit the subscribe button. Okay, now we'll talk about rules of recusal here. Like, what are the rules? So I hope you understand what is recusal. It is when a judge refuses to hear a particular case, or if there is any conflict of interest, he or she feels that they are disqualified, they are not eligible to hear a particular case, they recuse themselves. Okay, so talking about rules of recusal. So before that, I would like to mention about PSA also. As I mentioned that Omar Abdullah was charged under Public Safety Act. So basically, under Jammu Kashmir Public Safety Act 1978, a person is actually taken into a custody to prevent himself or her from acting in any manner that is prejudicial to the security of the state. So here, nation's interest matters. To maintain the public order, this is a preventive detention law, and this law can only be challenged by a relative of the person through a habeas corpus petition, which could be filed. So this is the only administrative preventive detention method here, how it can be challenged. So in the case of Omar Abdullah, it has been challenged by his sister. So now talking about the rules of recusal. So see, there are no written rules on the recusal of judges from hearing cases listed before them in constitutional courts. So it is left to the discretion of the judge. So there are no written rules, it depends upon the discretion of the judge. So the reasons for recusal are not disclosed in any order of the court. So some judges, sometimes what they do, they orally convey to the lawyers involved in the case their reasons for recusal, but there are many lawyers which do not do this, many judges which do not do this. So some explain the reasons in their order, but the decision here rests on the conscience of the judge. At times, parties involved, they raise apprehensions about the possible conflict of interest. So now the thing is, why judges recuse? So recusal usually takes place when a judge has a conflict of interest or has a prior association with the parties in the case. For example, if the case pertains to a particular company in which the judge holds stakes, so the apprehension would seem reasonable. Similarly, if the judge has in the past appeared for one of the parties involved in a case, the call for recusal may seem right. So a recusal inevitably leads to delay. So there is the consequence that it delays the particular case, because the case goes back to the Chief Justice, who has to constitute a fresh bench for it. Now another question is, should the reasons be put on record, like why the judges or any particular justice, they are not giving any reasons? Should the reasons be mentioned? So there was a separate opinion in NJAC judgment in 2015. Justice, he is now retired, Kurian Joseph, who was a member of Constitution Bench, he highlighted the need for judges to give reasons for recusal as a measure to build transparency. So it is the constitutional duty, he mentioned, as reflected in one's oath. When the justice, they take oath, they take the oath to be transparent and accountable. Hence, the judge is required required to indicate reasons for his recusal. That is what Justice Curran he wrote. So one of the companions of Justice Curran, he also wrote, he was also in the same constitution bench, Justice now retired Madan B. Lokur. He agreed that specific rules required to be framed on recusal. So the two judges were referring to senior advocate Fali Nariman's plea to Justice J.S. Keher, who was then in line to be next Chief Justice, to recuse himself. But what happens in case of Justice Keher? He refused to recuse himself, though he admitted that Mr. Nariman's plea left him in an awkward predicament. Justice Keher responded that he did not recuse himself for fear of leaving an impression that he was scared. So he did not recuse himself. Now there were some another cases also. In the case of Judge Loya and Assam detention center cases. So in 2018 what happened? Petitioners of Judge Loya case, they sought recusal of Supreme Court judges. So the judges which were about to hear the particular case, the petitioner wanted to, they should recuse themselves, they wanted their recusal. So Justice A.M. Khanwilkar and D.Y. Chandrachud from the bench, as they both hailed from Bombay High Court. So the case was banked on the written statements of the two judges from the High Court, where they both said that Judge Loya's death was from natural causes. So the court refused the request and called it a wanton attack. Now recusal of court, observed, would mean abdication of duty, maintaining institutional civilities, and if they are distinct from the ferociously independent role of judge as adjudicator, the court has explained. So even in May 2019, what happened? In the middle of hearing of a PIL which was filed by activist Harsh Mandir about the plight of inmates in Assam's detention centers, the then Chief Justice Ranjan Gogoi was also asked to recuse himself. But in a lengthy order, Justice Gogoi said a litigant cannot seek recusal of the judge. Judicial functions sometimes involves performance of unpleasant and difficult tasks which require asking questions and soliciting answers to arrive at a just and fair decision. So if the assertions of bias as stated are to be accepted, it would become impossible for the judge to seek clarifications and answers. So that is what the court observed. So Justice Gogoi, he gave a very befitting reply to the petitioners and litigants who wanted his recusal. He said that judge has to ask certain questions while investigating a case. When hearing a case in the court, you cannot judge the justice opinion through those statements which he is asking in order to know the real reason behind a particular case, right? Therefore, there are certain concerns which rise from the judge's recusal. First is undermining judicial independence. So, in taking oath of office, judges of both the Supreme Court and High Court, they promise to perform their duties to deliver justice without fear. So, in their oath, they say they will deliver their duties without fear and without favor, without affection and without ill will. Okay, so however, there are many cases where the litigant suggests that the judge should recuse himself from the particular case, but this will allow litigants to cherry pick a bench of their choice, which impairs the judicial fairness. And also, the purpose of recusal in these cases undermines both independence and impartiality of the judges. Then there are different interpretations also. For example, there is a rule that no person should be a judge in her own cause, but there are cases when somebody else's cause becomes a judge's own as case proceeds. Also, there are some cases where judge has appeared for one of the litigants at some stage in same dispute. So even then, as there are no rules to determine when the judges could recuse himself in these cases, different interpretations always remain there. And in the absence of rules, in disputes where a judge has a financial interest in the litigation, where a judge owns share in the company which is party to the case, the fact of owning shares is considered as a disqualification. Then it's not a recusal, it is a disqualification. However, when a judge, if he owns shares in one of the litigants, he should be allowed to disclose the fact before the litigants. And if neither party objects, the judge should be allowed to hear the case. But in the absence of a well-defined rule that helps establish a basic standard, a decision of this kind can actually prove troubling somewhere down the line. And also, when the judges choose without a rational motive, without expressing their decision in writing, they actually hurt the very idea of judicial rectitude. And along with that, a judge refusing the recusal in a case despite the existence of a bias in her or his judgment is equally destructive, right? So here, what should be done? For example, recusals should not be used as a tool to manipulate justice. Cherry picking should not be the case. Judicial officers must resist all manner of pressure if any kind of external pressure is coming, because this is their constitutional duty to be fair, to be impartial. So if they deviate, the independence of judiciary would be undermined, and in turn constitution itself. So hence, that is why again and again we are talking about rules of recusal, that rule that determine the procedure for recusal on part of judges, that should be made at the earliest. So this is all about today's discussion. If you have any queries, you can contact me on social media. PDF will be uploaded on my Telegram channel, that is t.me Veronica_Om, or you can just search Veronica StudyIQ. Thank you.
So this is the channel StudyIQ. If you're preparing for UPSC or any government exam, our pen drive and tablet courses are available. If you're preparing for UPSC CSE 2020, our pen drive course is available, where you can find 100% coverage of UPSC vast syllabus. Daily current affair updates will be available. Self-paced learning process is provided. This course has been prepared by top faculties of StudyIQ, and now you can purchase this course at Rs 625 per month only. For additional information, you can visit our site, and there are the phone numbers also given. You can call them and gain the additional information. You can connect with me for my video updates on Instagram and Facebook, because I feel together we can make a huge difference. For queries, you can even email me. Thank you so much.